The case of M.S.S. versus Belgium and Greece is a landmark ruling on the standards of returns of asylum seekers between countries that are parties to the European Convention on Human Rights, and particularly on returns to Greece. The case was of exceptional significance in defining the conditions that a country's asylum system must comply with in order to respect the Convention. The case was decided in 2011 by the Grand Chamber of the Court, which found the different violations against both Greece and Belgium. In relation to Greece, the court found a violation of Article 3 on account of the applicant's condition of detention and the living condition that he faced in Greece, which included homelessness and destitution. A separate violation was found on Article 13 in conjunction with Article 3 on account of the shortcomings of the asylum procedure in Greece. And separate violations were found against Belgium, both of Article 3 and Article 13. The M.S.S. case marked a turning point in cases concerning Dublin returns of asylum seekers from European countries to Greece. Following a separate case decided by the Court of Justice of the European Union in 2011, returns to Greece were temporarily suspended in 2011 and then resumed under some conditions in 2016 following a recommendation by the European Commission.
So why should the Committee of Ministers continue to supervise M.S.S? Since 2011, Greece has remained the main entry point for asylum seekers. In 2019, arrivals increased and the refugee population on the Aegean Islands reached record numbers since the EU30 statement. Many of the issues which brought the European Court of Human Rights to find Greece in violation of the Convention standards remain to date. That's why in June 2019, the Committee of Ministers decided to continue supervising the case, focusing on four main issues: the asylum procedures, the living conditions of asylum seekers, the reception and protection of unaccompanied minors, and the conditions of detention.
So insofar as the quality of the asylum procedure in Greece is concerned, the Committee of Ministers, in its supervision of the judgment in 2019, observed that efforts for the improvement of the Greek procedures had been made, but also noted that the asylum procedures continue to be time-consuming and shortcomings continue to persist. In our view, developments that occurred in 2019, both in Greek law and practice, could cause a serious degradation of the protection afforded to asylum seekers and migrants in the country. This is the consequence of two consecutive reforms of the Greek asylum law in November 2019 with the adoption of the so-called International Protection Act, and in May 2020 with the passing of a law which amended different provisions of migration law and asylum law in the country. These reforms went in the direction of reducing safeguards across the asylum procedure and are overall informed to a punitive logic. As was observed by many NGOs, the reforms struck a blow to vulnerable categories of asylum seekers. PTSD sufferers, for instance, were excluded from the category of vulnerable asylum seekers, and NGOs raised concerns about asylum seekers with special procedural needs being now no longer exempted from accelerated and border procedures. Other changes affected the Asylum Appeals Committee composition, which was changed, removing the UNHCR appointed officer previously involved in favor of a composition of judges. Asylum seekers' rights in terms of education, housing, and access to work were also affected as a result of the reforms. I will now pass the floor back to Ellie Criona to discuss the specific aspects of the asylum procedure in Greece.
So, according to the new legislation, the appeal brief must contain specific legal grounds, otherwise it will be found inadmissible. As per our observations in the field, this new provision has had a serious impact on the applicant's right to appeal. In particular, although according to the Asylum Procedures Directive, the provision of free legal aid at the appeal stage is an obligation of the state, no free legal aid is provided at Lesbos since there is no lawyer registered with the state free legal aid scheme, which is also known as the registry scheme. This has been the case already since May 2018. In July 2020, the Asylum Service of Lesbos tried to address this gap by providing remote free legal aid for appellants through the lawyers registered with the registry scheme of Athens. However, this practice has been marred with numerous shortcomings. For instance, in the majority of the cases, the appellants are not informed as to whether their case has been indeed assigned to a registry lawyer, or they do not have the possibility to meet the lawyer before the deadline for the lodging of the appeal expires. Actually, another issue as well is that this practice has been intermittent, as it is not always possible for the lawyers of the Registry of Athens to take up cases from Lesbos. Additionally, the new law requires that appellants under geographical restrictions on the islands submit an attestation by the Citizen Service Center or the police certifying that they actually appeared in front of these authorities 1 or 2 last days before the scheduled hearing at the Appeals Authority in Athens. The idea behind this is that through this attestation, the appellants confirm that they're still interested in their appeal being heard, although they actually only filed their appeal only a few days before. This attestation has to be sent to the Appeals Authority the latest 1 day before the appeal hearing. Otherwise, the appeal will be rejected as manifestly unfounded. Nevertheless, access to this attestation is very difficult, especially now considering the ongoing restriction measures in the camps due to COVID-19, but also because the appellants have to fill in a form that then they have to submit to the police or the Citizens Services Center, and this form has to be filled in Greek. And the third issue that they're usually faced with is that the asylum service has not been informing them that this attestation cannot be older than 2 days before the appeal hearing. HIAS is actually already handling the case of an appellant whose appeal was not examined on the merits because the attestation was actually 3 days old and not 2 days old. Further, according to the law, victims of torture must be certified by public hospitals and other public health entities. Nevertheless, no certification services for victims of torture are provided by the only public hospital of Lesbos, while no such services are provided by any other public health provider in Lesbos. This is very serious because the recognition of asylum seekers as victims of torture is inextricably linked to the proper examination of their asylum application. Actually, to highest knowledge, no certification services are provided anywhere in Greece. On the other hand, we have documented serious issues regarding the processing of the asylum applications of LGBTIQ+ applicants. For example, we have documented the use of unnecessarily sexually explicit questioning. For example, people have been asked to reenact their rape. In addition, interpreters have refused to translate statements of the applicants, or they have refused to actually complete the interview, or they have told the applicants that they are sinners. In other cases, we have seen that there is a lack of training because of the confusion of terms such as gay and trans, or the use of the word pedophile instead of the use gay. Due to these issues, LGBTIQ+ applicants often refrain from disclosing their sexual orientation and gender identity during their asylum interview. And this information is actually based on documentation provided by the LGBTIQ Solidarity Group of Lesbos. So regarding the processing time of the asylum applications, it's important to know that as of the entry into force of the new law, the Asylum Service of Lesbos has received instructions to deprioritize the cases of the pre-2020 arrivals and expedite the cases of those that arrived after the entry into force of the new law. Hence, new arrivals often have their interview scheduled 1 or 2 days after their arrival to Lesbos, and hence they don't have enough time to access lawyers' information or prepare adequately for their interviews. Conversely, the pre-2020 arrivals have their interviews rescheduled in 2021, and then they have to remain in the abhorrent and dangerous conditions at Moria camp for very long periods. I would like now to pass the floor to Adriana to proceed to the next topic.
So moving on to living conditions for asylum seekers in Greece, it should be noted that the Committee of Ministers acknowledged a need for improvement in this area. However, despite the government's claims in its action plan of June 2020, in the past year, the accommodation facilities in Greece, and specifically those on the Greek islands, have been systematically overcrowded, and have reached an all-time high in terms of overcrowding at the detriment of residents' quality of life. Amnesty International's researchers visited the informal parts of the camps on the islands of Lesbos and Samos in February 2020 and observed profoundly inadequate conditions of living. The residents interviewed by Amnesty lived in makeshift shelters or tents, mostly with no heating and no electricity. Some of the spots in the common areas of the informal parts of the camps were also overflowing with garbage, which contributed to make the place unsanitary. Common toilets and showers were also insufficient in number and often too remote to reach. Based on the direct observation by Amnesty International and consistent reporting by other civil society organizations, it can be said that residents continue to face unsanitary conditions, lack of proper medical care, as well as violence, including based on gender, which is particularly problematic for vulnerable categories. In February of 2019, the camps in Lesbos and Samos hosted a population which was of more than 6 and 11 times their official capacity. And overcrowding continues to persist to date. Also, the insecurity and lack of safety impacts people's mental health, including that of young children. Since late 2019, the Greek government has, however, taken steps to transition from the model of open refugee camps towards a new accommodation model that's based on closed control centers with an entry-exit system. The plans were consolidated with the May 2020 law and are currently under implementation. It should be noted that this is despite the Council of Europe Commissioner for Human Rights questioning how these models, how these new camps would be compliant with human rights standards. So far, there have been no indication of how this will be the case, and it continues to be unclear how a model that is based on restriction of freedom of movement and deprivation of liberty is compliant with European and international standards on detention of asylum seekers. The model itself is also particularly inadvisable considering the COVID-19 emergency. It should also be noted that the government also started a program to progressively disestablish facilities on mainland Greece, which contributed to overall reduce the reception capacity in the country. Aside from the issues faced by asylum seekers on the islands, broader obstacles have been observed in the past year in relation to access to healthcare and medicines in the public system. According to Greek law, asylum seekers should be given access to healthcare and medicines in the public system from the moment when they express their willingness to apply for asylum. However, since July 2019, the system in place to allow their access in practice has been repealed, and an alternative was only proposed with the November 2019 law and only implemented after April 2020. The system now in place continues to leave out some categories of asylum seekers and overall contributed to roll back the level of protection that was previously granted under Greek 2016 law. So, moving on to the issue of detention conditions in Greece, we would like to note that the conditions for asylum detention and pre-return detention in Greece have also become tighter during the past year. In the 2019 asylum law, which was discussed before, extended the maximum period of detention allowed for asylum seekers from 45 to 50 days. And in Greece, asylum detention is counted separately from pre-return detention, which means that people can find themselves facing very long periods in detention. With the May 2020 law, other problematic provisions have been introduced, which make the recourse to detention in pre-return cases potentially systematic, as well as in cases of asylum seekers whose appeal is rejected and who cannot be returned to their country of origin. I will now leave the floor to Ellie to discuss individual cases of detention in Lesbos observed by HIAS.
So our observations are mostly based on the pre-removal detention center of Lesbos, which is situated within the Moria camp. Although we consider the conditions in this center to be substandard in general, due to time constraints, we would like to focus on the issue of the provision of medical services in the pre-removal center. So as of March 2018, the provision of medical services in this center has been entrusted to AMI, which is a company whose sole shareholder is the Greek state. From the beginning of its operation, AMI's medical team has consisted of only one psychologist and one social worker, and actually the latter resigned in April 2019. AMI has been operating without interpretation services, with the exception of an interpreter who was actually hired only 2 months ago. There is no presence of AMI staff at the center during the weekends. There is no presence of doctors in general. Therefore, serious medical conditions often go unnoticed, while at the same time there are numerous reports of suicide attempts, outbreak of scabies, and other diseases. HIAS has also handled the case of a detainee suffering from kidney failure who actually had to be urgently transferred to the hospital in a critical condition, exactly because there hadn't been any medical follow-up on his case and he couldn't communicate his issues with ME. Additionally, we're aware of the case of an Iranian national who committed suicide in January, who was known for his serious mental health issues. And it is important to know that, unfortunately, during the critical period, there hadn't been presence of an IME psychologist in the removal center because of the Christmas holidays without any arrangement for replacement. We would also like to know the conditions of detention of those asylum seekers who arrived to Lesbos during the period of the suspension of access to asylum, that is in March 2020. We're speaking about approximately 500 applicants who were initially detained at the beach, then at the Mytilene port, and then at in a military vessel called Rhodos, before they were actually transferred to other detention centers in the mainland. So it is important to know that among these persons, we had the cases of people which were suffering from underlying diseases, very vulnerable individuals, persons in need of dialysis, asylum seekers in wheelchairs, people older than 80 years old, and unaccompanied minors. These persons were detained in abhorrent conditions, filthy conditions, in an overcrowded vessel with no access to running water or showers, with access to only 3 chemical toilets, with no access to adequate food, hygiene products, health care, and all of this despite the COVID-19 outbreak. Finally, although the supervision in relation to the access to an effective remedy to challenge detention conditions has now been closed, we still believe it's important to mention that the Administrative Court of Mytilene in Lesbos has not addressed the complaints about the detention conditions at the Moria Removal Center in none of the 17 cases represented by HIAS. I would now like to pass the floor to Adriana to discuss the next topic.
So finally, we would like to address the issue of the conditions affecting minors in Greece, and particularly unaccompanied minors, which has also suffered an overall deterioration in the course of the past year. It should be noted that between 2019 and 2020, 5 children, 2 of whom were unaccompanied, have died in the Moria Reception Center. And according to the NGO Doctors Without Borders, many continue to experience mental health issues. During Amnesty visit to Moria camp in February 2020, we spoke to unaccompanied male minors who lived in makeshift shelters in the informal area of the camp and complained about the difficulties in the age assessment procedure and the lack of warm clothing, as well as the broader difficult living conditions in the camp. It should also be said that the government has increased the places available in long-term shelters and flats, but the capacity of such accommodation is still insufficient to meet current needs. At the end of June, unaccompanied minors in Greece were over 4,600, and 211 of them were in protective custody in police station and detention facilities. The practice of protective custody of unaccompanied minors continues, despite the European Court of Human Rights finding in 2 cases in 2019 that such practice was in violation of the prohibition of degrading treatment and a violation of the right to liberty and security under the Convention. So based on the issues discussed, we would like to argue that the state and quality of the Greek asylum system continue to fall short of the standards required by the European Court in the M.S.S. case. Asylum seekers, refugees, and migrants continue to face risks in Greece, both with regard to the material reception conditions afforded to them and insofar as their rights in the course of the asylum procedure is concerned. As such, we believe that it's imperative that the supervision of the case of M.S.S. continues until Greece can adequately address the persisting shortcomings discussed in this presentation.